call to order at 5:35. Will you please conduct roll call?
Supervisor McCowan?
Here.
Supervisor Woodhouse?
Here.
Supervisor Jurdy?
Here.
Supervisor Hamburg?
Here.
Chair Brown?
Here. And I'd like to ask Mr. Frost Polly to lead us in the Pledge of Allegiance.
Hopefully everyone can hear me. Ready, pledge. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mr. Polly. This item, before we go forward on it, I would like to welcome elected officials that we have with us tonight. Councilmember Maureen Mulhern, Councilmember Jim Brown, and that's City of Ukiah, City of Willits, Councilmember Larry Stransky, Councilmember Holly Madrigal, Councilmember Ron Orenstein. Then representing the sheriff, because he couldn't be here tonight, Under Sheriff Randy Johnson, we do have District Attorney David Eister, and representing the Ag Commissioner, Assistant Commissioner Diane Curry. This is an informational meeting only. And I would like to, there could be possible action, so we will have public comment on it, but we're having a presentation by the Rural County Representatives of California, and this is on the 2015 State Legislative Medical Marijuana Regulatory Package. And with us this evening, I'd like to welcome Paul Smith. He has joined us, started working for the Rural County Representatives of California staff in 2005. He serves as a senior legislative advocate. And Paul represents RCRC, of which this county is a member, on a variety of issues, including county finance, operations, elections, labor employment, pensions, transportation, solid waste, corrections, and marijuana policy. And I'd like to welcome him, and we are going to have a presentation. I will allow questions from the board members. We may have a city official that would like to ask a question as well. I will allow that. And then we will go to public comment. So we're going to get started. Welcome, Paul. Go forward with your presentation.
Thank you.
So, she's checking. There you go.
All right, there we go. Good evening, Madam Chair and members of the Board of Supervisors and the public. Thank you for having me. Again, my name is Paul Smith. I'm with RCRC, Senior Legislative Advocate. Just real briefly, for those that are not familiar with RCRC, we are a 34-member association based in Sacramento. The 34 members are mainly the low population, rural and remote counties of California. Obviously Mendocino being one of them, and we very much appreciate Mendocino being part of our association, and I must commend Supervisor Carrie Brown for her work at RCRC. We really enjoy having her in her leadership and her participation in our activities. We advocate on a variety of rural issues, both at the state and federal level, and obviously marijuana, medical marijuana issues of that nature are very much on the foreminds of the membership. We're a supervisor-led organization, so supervisors from those 34 counties sit on our board of directors and make up our policy discussion. So just, again, get familiar with RCRC in general. It being a Monday night, there was no Tonight Show last night, so I didn't get any of my jokes ripped off from the Tonight Show. That's usually my forum for telling funny jokes before a presentation, so I apologize for the lack of humor. Hopefully you won't hold that against me, but I'll get right into the serious aspect of why we're here tonight, and that is obviously the issue of the 2015 medical marijuana legislative package that was adopted. Let me first start, as I always do, kind of some formalities here before we get into the meat of the discussion and offer a few thank yous to some folks. The county's role in this conversation was not done by me alone in either advocacy or development of policy. The first I need to acknowledge is my partner in this at the California State Association of Counties, Ms. Karen Keene. She and I were the Batman and Robin lobbying team on this for most of this year and in previous years. And also, believe it or not, the Urban Counties Caucus lobbyist was also very involved. It's amazing how much Los Angeles and Mendocino have in common. We don't always appreciate and know that, but there are a lot of urban counties that have some of the same issues that rural counties, and so they were very much a person in these conversations. There are key supervisors in the state, particularly rural and cultivating-oriented counties, and I always like to thank them publicly. And they are Supervisor Doug Teeter from Butte County, Supervisor Bob Williams of Tehama County, and Supervisor Judy Morris of Trinity County. Again, we're a supervisor-led organization, so having supervisor input was very, very important, and we needed to make sure. And you'll see that those three supervisors represented a broad cross-section as they approached this very controversial issue. Also, we could not have done the work that we did without some key county councils. Arthur Wyleen from Tehama County, arguably one of the most experts in the municipal world of marijuana, very much helped in this, as well as Christina Robb, Deputy County Counsel in San Bernardino County. And then finally, at the staff level, with all sincerity, Carmel Angelo, who had an enormous role for Mendocino County, but also the rural counties as a whole. There were many times that Carmel and I would be up late at night bouncing ideas off each other in terms of what this package means. And that was very special, I think, for Mendocino County and the North Coast, because she brings that perspective and shared it very, very well. We also didn't just leave out other important organizations in our advocacy role. The county ag commissioners, county health executives, county environmental health directors, those folks were also very much involved in a day-to-day conversation when we created this effort in terms of making sure the county voice was heard in the development of this package. Let me also say very clearly that in this conversation about this package and what RCRC's role and the county family's role was clearly about making any legislative package work for counties. We were not in the position, and we will remain not in the position, of advocating for or against marijuana. That is not what we were about in this conversation at the county level and the county advocacy level. We believe that's a decision left either by voters or by individual jurisdictions, in this case, counties. So it's not about RCRC's business to say we should do this or yes or no. It's clearly about building the confines of a regulatory structure that make it work for counties, and in particularly for RCRC cultivation counties. So there are a number of issues in this package that, quite frankly, I'm not really well versed on because they may not impact day-to-day counties. And some of those are in the public safety arena, some of those are in the physician-doctor relationship with patients, some of those are in the labor agreements, et cetera, et cetera. I will say that I really just cannot speak to those sections of the package. But what I can speak to, and you'll see shortly, is what this package does for counties. Where are your boundaries as you debate policy decisions that lie before this board and this board only? So, this all started about 2 years ago. My colleague Karen Keene and I were fighting bills that would create a marijuana regulatory structure in the last hours of the session 2 years ago. And the bill at the time on the table was one that made me scratch my head and say, why are we fighting this? And maybe we shouldn't fight this, and maybe we should figure out a better way. So we took that approach to the RCRC Board of Directors, and the RCRC Board of Directors developed very, very in-depth specific policy principles. I won't go through them all, but there's a kind of a photo of what they are, and you'll see they're quite extensive in terms of what they speak to in the overall conversation. There are 4 core policy principles outlined in that document I just shared with you: preserving local control, explicit county taxing authority, ending the collective model, and addressing environmental impacts. RCRC would not sign off, would not partake, would not agree to, however you want to call it, to legislation unless those 4 issues were addressed and addressed to our satisfaction. So the legislature, in the final hours of the session, went ahead and adopted three medical marijuana regulatory bills: AB 243, AB 266, and SB 643. One of them was authored by your Assembly Representative, Mr. Wood. The other, your Senate Representative, Senator McGuire, and then the other one was a very well-authored bill, mainly led by Mr. Bonta. And that co-author list was also included urban folks, rural folks, Democrats, and Republicans. It's a pretty long and twisty road to how we got to that package. It started pretty much last year, not this year, when the legislature was considering two bills, and obviously those two bills failed. But we also ultimately got to a bill package. It's a three-bill package. It was again unveiled in finality 10 hours before the legislature adjourned. 10 hours before the legislature adjourned. The legislature adjourned around midnight. We got this publicly around 2 o'clock in the afternoon. Obviously, you could not do that at a county board of supervisors level, but that's how the legislature functions, and it's very common. While I think most people would be aghast at that, I will say that 85% of the bill's provisions we had seen in some form or fashion. There was about 15% that was new. And to be frank, it's a very dense package, and there are still some things that I personally am going over, and I still need to flush out and have conversations with. But I think for today, feel pretty comfortable outlining what it is. It is also an interlocking package. It interlocks. You can't read one bill in a vacuum. You have to kind of look at the package as a whole, because some of the bills repeat provisions. Some provisions are right next to another, even though they're located in a different bill, et cetera, et cetera. I tell people that if you're having trouble sleeping at night, this is the package for you to read. First of all is local control. As mentioned, it is our cornerstone to any conversation about a medical marijuana regulatory structure. And that, what I mean by that is we wanted to make sure that local control, mainly local land use control, was preserved. And there are four sections of the package that speak to this. Some may see that as redundant and excessive. To be frank, it's not enough. During the legislative process, there were a lot more provisions which alluded to local control. The legislature, for a variety of reasons, dwindled those down to four. We'll go through them real briefly in just a minute, but I will tell you the main purpose for the redundancy is the issue of litigation. The reason why there are so many is because this is a very litigious area. Cities, counties have been sued extensively about their local control land use functions as it relates to this. And we wanted to make it infinitely clear that local control, meaning you have the ability to regulate time, place, and manner of medical marijuana, licensed medical marijuana facilities and whatnot, that you have the ultimate say at the Board of Supervisors level or the City Council level, just as you would with any other land use function. And that's what these four provisions attempt to do. So here they are. They're all referenced in the code section, as you will see. Most of them are in the Business and Professions Code. I won't read them in the sake of time, but you will see that, again, all four of them all have a common theme in them. This is the second one. And it's very, very important that references to the California Constitution in Article 11 are referenced in this. Again, a victory for jurisdictions in making sure they retain that authority. There's the third one, the fourth one, and we'll come back to this in just a minute. And those make up the four local control provisions. So what this means is, again, you retain the ability to decide how you want to have in your county, particularly cultivation, time, place, and manner, and you will have the ability to have great say in that licensing process. The second core issue was what we call explicit and broad county taxing authority. And there are basically three sections of the bill package which speak to this. The primary one is the one at top, 19348. What does this mean? I get a lot of questions about this. What this means is that the statute explicitly allows counties to levy a variety of taxes as it relates to the medical marijuana industry and licensing scheme. We anticipate that whatever action one board, or to a certain degree a city, but we'll stick with counties for a moment, whatever tax measure you would pursue, you would most likely, if enacted, get sued. And basically what we have said, and why we put this in here, is to make a 7-year lawsuit a 2-year lawsuit. Why would we do that? Why is that important? I always use the example of Trinity County, one of your neighbors to the north and east. If it were to enact a tax, it would most likely be sued. And if it drug out 7 years or something to that effect, the proceeds collected would all be spent on legal fees, leaving no tax revenues to actually do what the tax intended to do per the Board of Supervisors. And most likely that would be enforcement costs associated with the county. So they would incur all of these costs in the legal arena without it bearing any fruit. And what will generally happen is a county will make a decision to walk away from a tax, knowing that it has that obligation to defend it, and that it will be a costly obligation. Again, this shortens that time frame that we believe. As you know, and I'm sure many folks in the audience will attest to, you can tax medical marijuana, particularly cultivation, a variety of ways, particularly if it's indoor, it's outdoor, per plant, per parcel, per square footage, electricity use, water use, however you want to approach it. There are a variety of ways. And I can assure you that folks who don't like taxes, whether they come from the industry or not, will examine all of their legal options. The other point I want to leave you with on this is the language in 19348 does not speak to the process, does not change the process you would otherwise use for enacting a tax. It is the same process. If you were looking at doing a sales tax or a TOT tax or any of those things, you still have to get voter approval, and that threshold will be determined on how you would use those proceeds. So we do not change the process of enacting taxes. We just explicitly say that counties have that authority. Why counties, not cities? Cities were offered similar provisions, and they respectfully declined because they are basically governed by different sections of the Constitution, and city lawyers believed that they already have it and there's no need to explicitly say it, and explicitly say it could actually do more legal harm to their standing than otherwise. Counties took a different view. We are different in nature, and that's why you have it. The other section is the county authority to tax deliveries. We'll come talk about that a little bit more when we get into mobile deliveries, but it's explicitly referenced there. And finally, local fee and tax authority, 19320D. There's also another provision, 19350, that's not listed in the PowerPoint, but it's in other documents that we have. 19320D and 19350 are the local fee recovery provisions, meaning you have the ability to set fees to cover the reasonable costs of your licensing activities or your permitting activities or what have you at the local level. And we made sure that was explicit. The state was a big fan of this because the state will be using its fee authority as well. Ending the collective model. You'll see that was our third important principle. This kind of speaks for itself. Basically, the RCRC Board of Directors in our policy principles said we want to move to a licensing structure. We want to end the collective model that had been in place mainly since SB 420 was enacted. And we want to, again, move to a strict licensing scheme. And so you'll see in red, that is the operating provision that sets in motion a licensing scheme, plain and simple. And then finally, on our four key aspects, environmental enforcement. I will say that we wish we could have done more in this arena, particularly on the revenue side, and I'll get to that later. But nevertheless, the package does speak to environmental enforcement in many ways, and it also speaks to the ability to have a revenue stream to fund some of those environmental enforcement activities, and they are all outlined in the bill. There's no real specific code reference. You kind of have to look at 643 and particularly AB 243 to find them. They are pervasive throughout those two bills. But as you can see, they speak at great length to the issue of environmental enforcement. The package creates two licensure exemption categories. And what we mean by that is to undertake a personal grow or a patient caregiver grow, you do not need to obtain a state license. Personal grow exemption is not defined in this package. Patient caregiver's exemption is. And it's defined in two ways. One, by existing patient caregiver rules under the Health and Safety Code, and also the limitation that the caregiver can provide grow for no more than 5 patients. Hence, you see a physician or what looks like a physician or a caregiver, and you have 5 individuals. That was specifically put in there. The limitation is 5. In the package as it stands today, while those folks are exempt from state licensure, 11362.777G of the Health and Safety Code gives local control the ability to apply restrictions to those that are exempt. Let me repeat that. Under the Health and Safety Code outlined here, even though personal grows and caregiver grows are exempt from state license, they are not exempt from city and county regulating areas. I will tell you that this is highly controversial. It was a surprise that this section was retained in the package. We had advocated for very similar language in other aspects and in other bills at various times, and many of them were removed. This survived in the package, but I can tell you that this is probably going to be re-examined by the legislature. There's a belief that this probably should not have been in the package, even though we strongly advocated for it. So I will say that as of January 1, when this statute takes effect, this is the law of the state of California, and we will deal with, from our perspective, preserving this clause as best we can. But you should be aware that this will be, for lack of a better term, under attack, and there will be a lot of effort to remove this section of the package. But again, I'll repeat, as it stands today, the legislature has given local governments the ability to regulate and or ban the activities of personal grows and caregiver grows. I don't necessarily believe this is an issue in Mendocino County, but in a number of RCRC counties, this is an extremely important provision. So some key must-knows in the package as it stands today. First of all, the package requires a dual licensing process, meaning you have to have a state license and local approval to operate. Business and Professions Code 19320A does not necessarily specify how local approval is given. It references a license or permit scheme, and then there are other variations of what that permit could be, whether it's permissive zoning or otherwise. So to a certain degree, the local approval process is still not fully flushed out and fully uniform, I should say. I anticipate that 58 counties will do it differently. Perhaps as many cities as there are may do it differently as well. But it's envisioned that locals will probably want to engage in a licensing scheme, but that's not a requirement of the package. In the world of cultivation, cultivation applicants for a state license must commence their application at the local level and must obtain, again, a license or permit. There's that variation there. So cultivators will have to come before the Mendocino County Board or whatever designee you will have in this county to commence their application process with the state. Mobile deliveries. I will say that this van is a little facetious, but we thought we'd try our best attempt at humor. Other people also are suggesting that this might be my post-retirement activity, depending how things turn out here today. But nevertheless, mobile deliveries. The default is that mobile deliveries are allowed throughout the state. The burden is on a municipality to prohibit a mobile delivery and prohibit them by local ordinance. A mobile delivery also must originate from a licensed dispensary. Those are 3 really important things. So let me run through them again slowly. Mobile deliveries are allowed in this state on the natural. The default is they are permitted. The only way to not allow them in your jurisdiction is to adopt an ordinance. And the statutes are very clear that it has to be an ordinance. And again, that mobile delivery must originate from a licensed dispensary. I don't know, with all due respect, I don't know the culture of this county and the sentiments of this county, but I will cover this anyways, just for some clarity. First of all, the issue becomes can you have a mobile delivery occur going through your jurisdiction? So in other words, let's assume the city of Fort Bragg allowed mobile deliveries because they just remained silent on it. And let's say Ukiah, the city of Ukiah, went so far as to have an ordinance which said, yes, absolutely, this is what you should do if you want to do a mobile delivery. Can a Fort Bragg dispensary that's licensed deliver to a city of Ukiah patient? And the answer is yes. Can the county of Mendocino have a ban on mobile deliveries and interfere with that transaction? The answer is no. That if the originating and receiving jurisdictions agree to the mobile delivery, a law they do not have an ordinance prohibiting it, then those deliveries can occur. The other issue is can a dispensary from Healdsburg that's licensed deliver to a patient in unincorporated Mendocino County if Mendocino County does not have an ordinance prohibiting it? And the answer is yes. There is no restrictions on cross-county or cross-jurisdictions. Let me also be clear that this is much different than transporting. Transporting, moving, let's say, harvested marijuana off of the cultivation site on its way to a manufacturing site, that is a completely different scheme. That is all covered on the transport statutes, not the delivery statutes. This is very, very different. Also, the issue of third-party applications, meaning can you get on your iPhone and hit an app and voila, have a delivery within a few minutes. That was hotly discussed in the final days of the legislative session, and to the chagrin of, I think, counties and municipalities, that still remains relatively unregulated and relatively unlicensed. What's key there is that the delivery must still originate from a licensed dispensary. Lastly on that, the issue of transport. If, and I'll get into this real quick, and this is different than mobile deliveries, transporting. If a transportation occurs, if the cultivation occurs in Humboldt County and the processing facility is in Sonoma County and the preferred route is through 101 through Mendocino County cannot inhibit that movement, particularly if it stays on the public roads. So you cannot regulate and you cannot interfere with that movement. Cities have the option to enforce state standards. This could be a very interesting issue for this county, depending on the culture of the cities that you have in your county. The statute, as you will see, 19316B, allows the cities to petition the state to have full enforcement of this chapter. The issue for counties is twofold. One, if a city is granted that power and certain functions that a city would assume in enforcing the chapter fall on what is traditionally a county obligation, then the city must reimburse the county for those costs. What do I mean by that? Really what this is talking about more than anything is environmental health inspecting dispensaries, brownies, edibles, things like that. That is traditionally a function that lies with the county, not cities. Most cities do not have environmental health departments that do restaurant grading or enforce retail food laws. So in those circumstances, if that city were to do that, you would be protected with your costs that you would incur. If you have a contract with a city an existing contract with a city to perform those functions, those contracts do not automatically assume medical marijuana enforcement. So you're protected there. The other thing I'll leave you with here is that counties do not have this explicit authority. That doesn't mean that you might not be able to have it or use it. It's just not explicit. Quite frankly, I do not envision any county petitioning the state for full enforcement, but nevertheless, cities wanted this and were able to achieve it in the package. Local role in enforcement. It's very clear in the statutes that enforcement will be an obligation not at just the state level, but at local level. And that coordinated enforcement will take many different forms, whether it's enforcing transportation standards, environmental health standards, all kinds of things. There will be a local role. And quite frankly, the legislature assumes that and expects locals to be partners with the state in that. That also includes the ability to examine the financial records of licensees as well. Background checks. So to achieve a state license, applicants must go through a state background check through the Department of Justice. This is not an area, to be frank, that the county family spent a lot of energy on. This was, quite frankly, a law enforcement issue for police chiefs and others. But I think it's important for you to know, and I'll explain why in just a second. These are the listed items in the statute that will most likely trigger failure to obtain a state license. And I put them as much as I could in regular lay language. They're pretty common sense. You would expect that these folks that had committed and been convicted of these offenses, that they would have a difficult time obtaining a license. But nevertheless, there they are, and there's the code section that more specifically outlines them. The question I alluded to a moment ago was, can a jurisdiction add to this? Meaning, can a county say, you know, we want to be a little more stricter on who we would give a license to, particularly at the local level? And the answer is probably, and the answer is you will also probably be sued if you do that. Don't know if you will win or lose, but you are likely to face litigation if you do that. But again, there's nothing prohibiting you from going down that route. Employer restrictions. These are the other relevant aspects of the package. You retain, through sections of the code, your ability to set employee use restrictions on medical marijuana. Very, very clear. This was an extremely important part. It wasn't necessarily one of our core policy things, but if we'd had a fifth, this one probably would have been it. This is to protect you in compliance with the Federal Drug-Free Workplace Act. As you know, to obtain a lot of federal grants and federal monies, you basically, for lack of a better term, have to swear allegiance to the Federal Drug-Free Workplace Act. And of course, that means you have to basically abide by that with respect to your employees using controlled substances. So what we said is that we want to empower your ability to set those standards. I will tell you that this is not just on-site, on-work rules. This also applies to off-site, after-hours marijuana use as well, and you can set those standards. I covered the transportation standards really briefly. On one aspect. The other aspect that you should know is that transportation standards are very minimal in the package. The only two things that are really required here is, one, transporters must be licensed, and in part of that licensure they have to be bonded and insured. And the other aspect of transportation standards is they have to have a manifest that's always available for inspections at all time when that product is moving. What's not in this aspect is time restrictions, manning restrictions, unmarked versus marked, et cetera. All of those things will be developed by the state regulators, most likely the Department of Consumer Affairs and the Bureau of Medical Marijuana Regulation. Pesticide standards, very similar situation. This is where the legislature punted to a large degree, and it punted to the Department of Food and Ag as well as the Department of Pesticide Regulation. They will be charged with coming up with standards. We also put in some cross-ownership restrictions in the package. This was a very important issue, particularly for RCRC, but other municipalities and other players and stakeholders. And basically, I can address those probably if there are questions, because it's a very complex area. But the bottom line here is that we attempted to put some restrictions on folks who would otherwise own licenses through all categories. We basically wanted to avoid vertical integration, where someone is a retailer, a manufacturer, a grower, and they own all aspects of the distribution chain. We didn't think that was appropriate. We spent a lot of time talking to the alcoholic beverage industry about this, and that is pretty much how it is done in the alcoholic beverage world. Part of that alcoholic beverage world is what we call mandatory distribution, and the package does have a mandatory distribution where marijuana needs to move through a distributor tier, for lack of a better term. That's done for several reasons. One, testing. Product testing is very important, and it's outlined in the package. It's also done because it's easier to collect taxes, particularly those cultivation taxes. It's much easier to collect a tax from 10, 12, 20 distributors in the state as opposed to hundreds, if not thousands, of cultivators. Finally, the removal of C4, and I'm sure we're going to spend a little bit of time on this because this is very important in the package. C4 is found in AB 243. This is the clause that's got a lot of counties and a lot of jurisdictions very concerned about the timing into which they need to have a cultivation ordinance in place. First off, let me say that this was a section that was not supposed to be in the final package. Assemblyman Wood, the author of 243, has committed to authoring legislation to remove C4. That will likely require a 2/3 vote and immediate action when the legislature reconvenes in January. It's tough to bet on the legislature doing what some members want it to do, but taking this at face value and assuming this does come out, I expect it to come out sooner than later, and we would most likely avoid the headaches of trying to implement C4. What C4 basically says is that if a jurisdiction does not have a cultivation ordinance or does not plan on administering through a conditional permit program sections of AB 243, that the state becomes the sole licensing authority for cultivation. And again, you can see why that might be problematic already. One, it forces jurisdictions who don't have ordinances to do something before March 1, 2016. And it also forces them to make a decision of whether or not they can ever be a player, meaning can they ever have the licensing authority if they go beyond a March 1 date and the state takes over. So to clear up that ambiguity and confusion, Mr. Wood is committing to removing C4 in AB 243. As a matter, though, of policy, and again, I'm not sure it's that relevant to the county of Mendocino, this might be of more interest to the cities in the room. You cannot bet that this will be removed. I'm going to make that very clear. The legislature still needs to take action. They would most likely require a 2/3 vote, and they would have to do this sooner than later to avoid any before a March 1 thing. That's generally a very difficult thing for the legislature to do. So again, don't assume that this is going to be removed despite the best intentions of Assemblyman Wood. The legislature is not the only arena that that efforts are occurring to address medical marijuana. I'm sure you're very aware that the North Coast Regional Water Quality Control Board has adopted a regulatory package on cultivation activities, namely having a waste discharge waiver. It was adopted, as you can see, earlier this year, just a couple months ago. It is also being exported to other regional water quality control boards, namely the Central Valley. So if you put the North Coast and the Central Valley together, you're looking at probably about 2/3 of all of the cultivation that occurs in the state. These are some of the key elements of the waiver. And again, I'm sure many of the folks in the room are already aware of this, and maybe you and your staff are too. The big thing here is that to obtain that necessary, for lack of a better term, permit, although I really shouldn't use that word, but let's just use it for the sake of the argument here. To obtain a regional water quality control permit to cultivate, there must be a deference to county ordinances. And so that's very, very important. If you have a ban, then the Regional Water Quality Control Board is not going to issue any of those waivers to those cultivators in that jurisdiction. Again, not necessarily an issue here, but just be aware that there will be some dovetailing. RCRC provided comments to that. We are full support of both jurisdictions' efforts on this. We think it's the right thing to do. It gets us, again, down the road of a complete scheme, which comes back to that very, very important core principle, which was environmental enforcement. We're not just doing it through statutes, we're doing it through regulatory efforts as well. By no means is this conversation over, particularly in the legislature. There are two key bills that you should be aware of. AB 1548 and AB 1549, both authored by your respective assemblyman, Mr. Wood. The first is, I think, very important to folks in this room and this county, and that is AB 1548 levying a cultivation tax. This is what Mr. Wood is proposing. The bill is in print. He is ready to move it when the legislature returns. You can see the various levels that he is proposing. Again, no surprises here. This is exactly what we would expect. I will say that the cultivation tax was part of the package that Mr. Wood sought in 243 earlier this year. Tax increases are 2/3 votes in the legislature, meaning you have to get Republicans who are always very nervous about taxes. And of course, there are some moderate Democrats who share that concern. So it was removed because of the need to expedite this package on the last night of session. Therefore, Mr. Wood has his standalone bill. Here's where the proceeds of what that tax would be used for. It's very prescriptive. And you can see it is virtually all of it to address environmental impacts. I will say that we will be taking AB 1548 to the RCRC Board of Directors. So Supervisor Brown will have an opportunity to weigh in on this. We will ask the RCRC Board of Directors to adopt a support if amended position. The amendments we are seeking are very modest. They basically ask that the language be written that cultivation tax does not interfere with your county taxing authority, that they are two separate and distinct tax avenues. And second, we want to make sure that the proceeds aren't just for law enforcement activities, that they are for all enforcement activities, not just the sheriff or police or those. It's for code enforcement, environmental health, etc. The second bill is AB 1549. This is what we call a spot bill in the business that I'm in, meaning that it basically says something, but the details really aren't there yet. And that is basically what Mr. Wood is trying to attempt to do here in creating a state banking scheme, a financial institution scheme, for lack of a better term. As you know, unfortunately, because of the way federal law is structured, this remains an all-cash business. We don't believe that is healthy at RCRC. We don't believe it's healthy for you to accept your property tax payments in cash. And any other monetary exchange, whether it's through a public agency or even just folks walking about town doing business in this new legal structure. Obviously, Mr. Wood shares that same concern, and he is authoring a bill to try to work through the federal banking laws and create some type of state financial institution. We will also be asking the RCRC Board of Directors to support this effort as well. Finally, you really can't talk about the medical marijuana legislative package without the big elephant in the room, which is a ballot measure or ballot measures that would put forth an adult use or a recreational scheme. Again, this package that we've been going through for the last 25, 40 minutes, it speaks to medical marijuana. It does not speak to adult use or recreational. And so the issue is, will we have separate regulatory structures, different rules in one set versus the other? And I think that's very, very important. I will offer this as much as I can, and that is, you all are aware that there are several ballot measures that have been filed in the initial steps to reach the ballot for a November 2016 conversation. My sense is that to get it all the way there is probably going to be boiled down to one or two ballot measures. I will tell you that the proponents of those that are very well funded and can probably get all the way across the goal line, RCRC, CSAC, and others, have been having conversations with them. And the effort is to try to duplicate and create as much parallel between the regulatory and taxing structures that exist for medical as they do for recreational. We're probably a good 3-4 weeks from starting to run into some serious deadlines for proponents to submit and commence the process. When we get past late November, December, the costs go up, the questions get a little thornier, and so we're probably going to see some final movement here in the next several weeks as to who files what, where, and how. Also, you should be aware that the legislature will have the opportunity to intervene in initiative-driven ballot measures. And so there'll be some conversations in the legislature about these measures once they qualify to see if there can be some alterations. And we will be very engaged to, again, make sure that the gains that we made in the medical side transfer over into the adult recreational use side. With that, Madam Chair, that concludes my remarks. I tried to be as quick as possible, but I'm here to answer any and all of your questions.
Appreciate it, and I know that Supervisor McCown's been writing right along, so I know he has questions. Oh, sorry about that. Supervisor McCowan
Thank
has
you, Madam
questions.
Chair. Well, I'm sure we all have many questions. The one I want to ask begins at the end of your presentation. And first of all, thank you very much for taking the time to come here and make this presentation. It's obvious that you are, if not the subject matter expert, certainly one of them. So thank you. The ballot initiative that, just to me on the face of it, has a good opportunity to make it across the finish line would be Reform California, which they've rolled out a version. And do you have an opinion, if you had a chance to review that and make an assessment of what impact that would likely have on the local control measures that are contained within this legislative package?
I have not read that one, so no, I can't. I just became familiar with what we call the Sean Parker Initiative. We were given a heads up a number of weeks, months ago about that one. I've not been able to meet with Reform California. We have also met with the Drug Policy Alliance's version as well. My understanding is that has also gone some revisions from when we first met. But obviously I will be reaching out to Reform California and getting a better understanding of what they're proposing.
Thank you.
Okay. Any city official, council member would like to ask a question of Mr. Smith? Seeing none, Mr. Eister, do you have questions? Okay. I'm going to go with questions first, and then we'll have you down here. Okay. Seeing none, Mr. DA, would you like to come down and give some comments?
Good evening, Board. This was a very good presentation. You did a very good job on this. I just got done last week doing the presentation on this very same subject matter for the California District Attorneys Association. So there's a couple things that are important. Can you take me to your slide of the five caregivers and the personal use at the very start? Right there. This is an important slide because the way this law is written, if it's not personal use and personal grow, and it's not patient caregiver, then by definition it's commercial, by definition. So these are the two exceptions to commercial right here. And if it's commercial, that's where you're going to see fees, and this is where you're going to see the taxing authority. And that's how they're getting, that's why they need to get the collective model out and the likes. So these two areas right here are very important, and the caregiver exemption where you can only have 5 patients is critical so we don't have, you know, a collective where there's 20,000 members sort of thing. So you keep this in mind, and that's where the taxing authority is. When I was talking to the District Attorneys Association, I called this package of bills the Jerry Maguire package, because if you remember that movie, the theme of that movie was "Show Me the Money." So that's in essence what's happening with the commercial aspect, what will be commercial marijuana for the counties, cities, and for the state. The type 11 distributors that he talked about are very important. I kind of call those the white knights. Those are going to kind of be the middlemen that are going to help to try to keep some order in the system. And there's about 12 licensing models. I count 17, but they call it 12. That'll be subject to licensing and fees and taxation. So it's I guess he started out with the best thing he could have said. This is a very dense package. And to read through all these bills and put them in order does take a lot of effort, and so I commend you on that. I think the board's going to have to spend a lot of time talking about some of these things. Measure D in LA was preserved by all these bills, and Measure D allows them to limit dispensaries down in LA. In LA, they're taxing dispensaries at the rate of $60 per $1,000 gross receipts. So that's an idea of how much taxation is on this whole thing. And that's one of the things you're going to have to look into is I think there has to be some consistency between, certainly on the North Coast, but throughout the state, so that counties aren't taking advantage of one another in the whole final analysis here. So I thank you for your work on this. This was very good. Board, you have a lot of work ahead of you.
Thank you, Mr. Eister. Under Sheriff Johnson, do you have any comment this time? Okay. All righty.
Madam Chair, can I ask a
yes.
question to
Yes.
Paul? Since we're on this slide, what is a personal grow?
Excellent question, Supervisor Hamburg. I will say I really don't know, and I'm not sure we really do know. There are no definitions around this in the package. There are conversations about perhaps setting a limitation on this on the adult side through the initiative process. There have been ideas bantered around as to doing it by plant size or yield size or putting some type of definition. But as it relates right now, under this package, there's really no definition.
And on the other side of the slide, if you're utilizing the patient caregiver exemption, how much marijuana can you grow for each of your patients?
It's not defined. It's not defined.
That's kind of a big
It's a big loophole.
loophole.
It is a big
If you ask
loophole.
me.
And now that you brought it up, I was going to follow the district attorney on this. The district attorney talked about the term commercial. We advocated that the term commercial be removed throughout the entire package, so we speak to marijuana, period, not just commercial marijuana, to get at some regulatory parameters of these two types of exemptions. The legislature was very sympathetic to patient caregiver grows, personal grows. They believe the spirit of Proposition 215 was to make sure that there was proper access. And so there was pretty much a desired attempt to not put parameters on them in the legislative package because of that.
Please come forward.
I'm not the chair, David.
I know who the chair is.
I know you do.
Restate your name for the record.
David Eister, District Attorney. I think when we say the bill doesn't speak to things, that was intentional. The Bureau of Medical Marijuana Regulation, what I call the pot czar, they're going to be tasked with the job of coming up with all the regulations that are going to apply. And so, as you see, as this bill comes in, sure, it goes into work in January of 2016, but there's a lot of deadlines down the road. And so that whole bureaucracy, and it's in the Department of Consumer Affairs, they're going to be coming up with all sorts of rulemaking and regs that are going to force every question that you're talking about.
Okay.
Okay? Thank you.
Okay, thank you. Supervisor McCowan.
Thank you, Madam Chair. So in the ambiguity is somewhat reminiscent of Proposition 215, of course, but if I understand you correctly, these exemptions notwithstanding, they would still be subject to any local ordinances, either city or county, that may be in place.
Yes, Supervisor McCowan, there you see it in black and white, Health and Safety Code 11362.777G, what we call Section G in the package. And that is your ability to set some local parameters on those that are exempt. And again, this is extremely controversial. We will have to be vigorously fighting this to preserve this because, again, There are those that believe that this should not have been in the package, and we see otherwise.
Madam Chair?
Yes.
Well, we may not need to fight it if the district attorney is accurate, because there is this rulemaking or definitional phase which is down the line, and right, isn't that what you were saying, district attorney?
That's what I was saying.
Right, exactly. And could I ask one more question? You've been using the date March 1, 2016, and of course there's January 1, 2016. What is the effective date of this package of bills?
That's an excellent question. The first key date is January 1, 2016. That's when these statutes become effective, where they can become effective.
Okay.
The second date is March 1, 2016, and that is in that C4 that I referenced, and that's the
Okay.
date that a jurisdiction would have to have a cultivation ordinance or abide by the provisions of AB 243, or you surrender your licensing authority solely to the state. That's the second date. The third date is January 1, 2018, and that is the presumption date that licenses will be made available by the various licensing agencies. CDFA for cultivation, public health for testing, dispensaries and transporters will be under the Department of Consumer Affairs, et cetera, et cetera.
And why that gap of time? I don't understand why they put that off to 2018.
Because it's going to take, as I mentioned, there's a number of punts, if you will, the transportation standards, the pesticide standards, and
Okay.
others. It's going to take time for those regulatory bodies to move forward with their rulemaking. The other thing you should be aware of is that the statute yields to those in good standing now continuing to practice as they are.
Okay.
So leading up to those, particularly that January 1, if you are in good standing, for all intents and purposes, the law sees you as being a licensed entity, even though there's not licenses yet. Those are preferred licensees. They will also most likely be the first at the table to get those licenses after January 1 because they're in good standing and been already in practice. So the world doesn't really end between January 1, 2016 and January 1, 2018. There's a lot of wiggle room.
Mm-hmm.
Supervisor McCowan. Okay.
If I may, Supervisor, the issue of the dialogue with I forget the gentleman's name, the DA,
David Eister.
with Mr. Eister is if the issue is if you ban all types of marijuana in the case of Fresno County, then that rulemaking discussion that the district attorney just had, that really becomes moot.
Right.
And that's the other dynamic that's going on here is you have Fresno County, who's in litigation right now over their ban. They have what we call a hard ban. And so this would really make those other discussions kind of moot in those hardcore counties where there's absolute bans. There's no wiggle room in regulation. I agree with the district attorney. In those counties that want to regulate, yes, there's obviously some wiggle room. We'll wait and see what the various licensing agencies come up with. But again, in all ban counties, there's not that flexibility.
Could I ask one final question of Paul?
Yes, and then we have a city council member that would like
I
to.
realize that. Can you just let me ask one question? Paul, would you advise counties to follow the model of Humboldt and enact ordinances prior to January 1st, 2016?
I'm not
so that
from-
we can issue licenses prior
not-
to the effective date of these bills?
Supervisor Hammer, I'm not familiar with the details of them, but what I would say this is there's nothing to penalize you from acting early. And what I've been telling counties is go ahead and dust off your ordinances that you have now, or if you're in the process of creating one, go forward and try to beat that March 1 deadline if you can.
The March 1 deadline and not the January 1
Correct.
deadline?
Correct. You're
That's
running.
very interesting.
The clock is. You're an incumbent. You have an incumbent ordinance, so it's a little, I think, politically easier maybe for you than others. But if you're starting from scratch, it can be very, very difficult, and I've seen that occur in San Benito County and Calaveras. But you're going to have to come up with some new structures, anyways. And so my advice is why wait for January 1, 2018? Why wait for March 1, 2016 if you can? To get something in place sooner than later. Of course, I always say this, the caveat is you need to work with your counsel to make sure you're
Yeah.
comfortable with the language that's in these statutes.
Of course. Thank you, Madam Chair.
Thank you. Please state your name for the record.
Ron Ornstein, City of Willits, City Council. Thank you very much for the presentation. There's a lot to absorb here. But looking at the slide that's here right now, I just want to make sure I understand exactly what I'm reading here. And what it says, I believe, and correct me if I'm wrong, is that we have the exempt categories, but the city can regulate, ban the cultivation, storage, manufacture, et cetera, as it says. Does that all, I don't see the words sale or I guess technically exempt caregivers don't sell the product, they give it. So I guess that's implied.
The word provision is the key word there, sir.
Okay. So does that say what I think it says, that even exempt categories can be banned excuse me, from doing business in our city if we so rule?
Yes, that's what we believe it. The lawyer who wrote that was clearly his intent. I know the lawyer who wrote it. And yes, that is definitely the intent.
But I think you also did say that it may or may not be challenged.
The legislature is likely to revisit this section. There will probably be a move to remove it. I know there are various advocacy groups are asking for that now. And so the question is, will this stay and how long will it stay? I will also say that I would be very, very surprised if any of the ballot measures retain any of this as it relates to personal grows. So again, I would urge caution about implementing things on this. But as of January 1, this is the law, and you have that authority to regulate those that are exempt.
Okay, thank you.
Thank you. I don't see any other questions from elected officials. I would like to recognize and ask commissioners if they'd like to come up, or a representative of the Juvenile Justice and Delinquency Prevention Commission. Please come forward, state your name for the record. And you have written a statement on marijuana in youth, and I want it, if you'd like to read it into the record. State your name first, please.
Thank you. My name is Kate Gaston, and I'm a member of the Juvenile Justice Delinquency Prevention Commission of Mendocino County, and I live in the city of Ukiah. I'm going to read the statement that the commission wrote. The mission of the Juvenile Justice and Delinquency Prevention Commission of Mendocino County is to advocate for a quality system of care for juveniles and to promote services, resources, and opportunities for young people in this county. With this in mind, we are concerned about the potential negative impacts on youth on the impending legislation of recreational marijuana, which can also be applied here too. We support the idea that adults are free and able to make choices around marijuana use. However, while recognizing a range of individual differences among young people with respect to both physical and mental health, we note a growing body of evidence that frequent use of marijuana can negatively affect adolescent brain development. Although some young people may have the skills to make healthy decisions, many are vulnerable to long-term impacts on personality development, engagement with school and other activities, and possible involvement with the juvenile justice system. We therefore support limiting the legal sale and recreational use of marijuana to adults ages 21 and over. When marijuana becomes legal for recreational use in California, the law must assure there is taxable revenue available for education, research, prevention, compliance, and assistance for treatment when a youth is adjudicated for marijuana possession or use. We must also assure that there are strict marketing rules preventing the targeting of youth with this product. In addition, and this is important, funding should be made available for more programs that offer youth opportunities to develop skills, to follow academic and/or career paths, and to engage in healthy recreational activities. In this way, providing alternatives to the use of marijuana and to employment in the industry. While we do not want to criminalize youth for infractions of the marijuana law, we do want to hold them accountable for their behavior. School-based educational and mentoring programs can be valuable alternative interventions when a poor choice is made by a youth concerning marijuana. We are bringing our concerns to the attention of parents and the larger community to engage their support for a law that includes protections and supports for vulnerable youth. Thank you.
And I would like to ask you, are you going to be transmitting this to any of the other commissions around the state and also to our legislators?
Yes, I think we wanted to do it here first.
Okay.
And I think we've learned so much more about the adolescent brain and the effects on chemicals in the adolescent brain because they change. There's a time period between 13 and 18 or 19 that the youth brain is so vulnerable. So we felt it was important, just like they've had to go back and do for alcohol and cigarettes. I mean, they had to return to this issue then to put these in place. So this is proactively, let's think about it this way. So.
Okay, but I would like to recommend you do get it to Senator McGuire and Assemblymember Wood.
Definitely.
I think they would appreciate that.
I think you're right. That's where we need to send it. Thank you so
Okay,
much.
Thank you. Okay, next, moving forward, we will have public comment. And our first speaker is Madeline Mello, and she'll be followed by Frost Polly.
Good evening. My name is Madeline Mello, and I'm from Fort Bragg, California. And I just want to make a few comments, and I'd like to ask the chair, am I allowed to ask questions?
We weren't going to have that happen, but you can direct your question to me.
Okay. So I'd like to make a couple of comments first. As all of the Board of Supervisor members know, the Jerry Mello Foundation was founded about 4.5 years ago with the sole intent to educate the public about environmental degradation and safety issues for workers and people that recreate in the open, out of doors. Also, our concern was for the safety of wildlife and the issues that marijuana presents to them in the way that marijuana is cultivated, especially on properties that are trespassed upon. So while I welcome all of the hard work that all of you have done and that all of our legislatures have done, I do think this is a watershed moment for all of us. And I want to thank Paul for coming in and bringing all this information. As we know, passing a law doesn't imply that there will be compliance. So we must continue to be vigilant in making sure that the environment is protected and that our animals and people are protected from the harm that can happen. And I won't go into all of that. All of you know that. There was one large missing thing from the law, and that was an educational component. And I applaud the lady who just spoke because there's so many things about education that needs to be done around these bills. And I am truly hoping that the Bureau that manages all of this will put education as a primary importance. And this is my question for Paul, which I will direct to the chair. I read all three bills, and in the bill it talks about a marijuana research center. And I'm unaware of such a center. Is that center going to be set up under these bills? Does it already exist, and how will it interact with the Bureau?
Thank you. Mr. Smith, would you like to answer that question, please?
Yeah, the short answer is I don't know. Again, that was not a core issue for us to track. We were busy fighting those, but I think it's a very worthy question. Hopefully we can find the answer.
Thank you. Mr. Polly, restate your name for the record and know you have 3 minutes.
Thank you, Madam Chair and the entire board. Frost Pauley, President, Mendocino County Farm Bureau. I'd like to make a few brief comments just about our concerns at Farm Bureau going forward. And before I start, I just want to say thank you all for taking this very seriously. This is an important issue. It's going to have long-term impacts on our communities here in Mendocino County. It's great that we're starting this conversation. We have a lot of work ahead of us. I hope that you'll look to Farm Bureau as a partner moving forward in the process. I think Mr. Smith made a great point when he said there's really no reason to drag our feet. We might as well jump right into this and work towards getting something done before January 1st if possible. We need to start looking at the 9.31 ordinance and how that can be changed to accommodate these new rules. Right now, as it stands, that's a nuisance ordinance. My understanding is that it can't stay there. So as a Farm Bureau member, my concerns would be how it's going to impact zoning and land use going forward. Assuming we're going to change that ordinance to a zoning ordinance, for example, what those impacts and possibly unintended consequences could be to those issues of land use in particular, and one that stands out for Farm Bureau members is any impact to the right to farm ordinance. That is incredibly important to our farmers and ranchers here in Mendocino County. It not only protects our rural way of life, but it also protects agriculture from urban encroachment. So that's one area where I think Farm Bureau can work with you guys. If there's any question about how something is going to impact, any new rule or regulation is going to impact agriculture, unintended consequences, we look forward to hopefully answering any questions you have and can be a partner moving forward. Thank you very much.
Thank you.
Thank you. Casey O'Neill, and Casey will be followed by Edward Dick.
My name is Casey O'Neill, board chair for California Growers Association and a local generational cannabis farmer and a vegetable farmer, 2 farmers markets and a CSA. Madam Chair, Supervisors, thank you for looking into this issue. We appreciate the presentation by Mr. Smith. California Growers Association, we're looking forward to being part of this process and working with y'all on implementation, figuring out how this is going to work. I think we've touched on the environmental crises of unregulated cannabis cultivation. We've touched on some of the social ills, and I think it's very important that as we move forward, we maintain this stakeholder conversation so that we can figure out how we build a license system that supports the small farms and the independent businesses who call Mendocino County home. Thank you.
Thank you. Edward, oh, here he comes.
My name is Ed Dick. I live in Redwood Valley on Tomkai Road. Been there since 1990. Had not really been directly involved in any of these issues, but I've come to see that it's an issue that is profoundly important to the economy of our county. At the end of the Prohibition era of alcohol, Napa County vintners and vineyard growers positioned themselves very well in terms of establishing a reputation that continues to impact that market today to the detriment of Mendocino County farmers. We've had an uphill fight developing that reputation. We're not now in that position with respect to marijuana. Mendocino County is known for the expertise in all aspects of its cultivation and development and the marketing, all aspects of the genetics of the plant on a statewide, on a national, and even on a worldwide basis. I think it is incumbent upon the Board of Supervisors at this point to seriously look at the impact of its actions today over the next several years, even several decades, as the world changes around these issues. We have the opportunity, the economy of marijuana growing is significantly different now than it was 3 years ago. I understand, I mean, I don't know, but I understand the market was, you know, like $3,000 a pound a few years ago, and now it's down to somewhere around $800. That's what I hear. Okay, with that economic difference, you are going to lose the capability of maintaining the quality of the industry corner that you have now, unless acts are taken to make that possible. Thank you.
Thank you, sir. Julia Carrera.
Hi, Julia Carrera. First of all, thank you, Paul Smith. You did such a good job that you convinced John McCowan you're an expert on the subject matter, and you got a good job from our district attorney who doesn't give those good jobs out very easily, so thank you. I'm here today representing myself, Julia Carrera, and Associates third-party inspector, but also the Small Farmers Association and the small farmers that couldn't be here tonight. Off of what Edward just said, you have an opportunity here. We're in transition. Economically, you have a constituency, each one of you, that is struggling and can't make it. They can no longer afford to pay people to work for them. They are working 12 to 18 hours a day. We need a plant count increase now so that we can participate in this regulatory package in a way that our reputation allows us to do so. Thank you.
Thank you. Armando, please restate your name for the record. No, you have 3 minutes.
Armando Soto.
Could you pull the microphone down so be sure to hear you? Thank you.
Just the recent governor's report regarding legalizing marijuana in general said that the tax regime should not be oriented towards maximizing tax revenue, but because that, as we've seen, like in Colorado, has led to still the proliferation of the black market. So try to be a little gentle on the taxes. And cities which following that decide to, and counties that decide to try to do a ban will probably find themselves in a legal morass like Fresno, so that's probably not the best idea. So that's all I have. Thanks.
Thank you, sir. Sherry Glasser. And she'll be followed by Tim Blake. Please restate your name for the record and know you have 3 minutes.
My name is Sherry Glazer. Thank you for having this hearing today. Thank you so much, Mr. Smith, for coming. Thanks to the board and everyone here who has spent a lot of time on this issue and a lot of hard work and risk. And I find there's a lot of courage in this movement and a lot of people operating as safely as they can and trying to stay within regulations that have always been very gray. So now we have some regulations, and it's very exciting for us. I think there's an eagerness, too, to become licensed. Everybody would like to get into that new office, the Department of Medical Cannabis Licensing. And I hope that you see this March 1st deadline as a goal, that by then we'll have that bright, shiny office, and that we can walk in, whether it be cultivator or whether it be dispensary or distribution. It's not that difficult to set up. You just need a little corner office. So, and I would ask that also for you to take into account the dispensaries that have been operating, providing the highest quality medicine to patients who are facing life-threatening diseases, sometimes dying of cancer. A lot of times, as a last resort, they come to these dispensaries to save their own lives and those of their families. And we would love to see those licenses for dispensaries immediately granted for those operating in this county for many years, and we would love to have that partnership with you and that recognition from the county that we have the seal of approval. Thank you.
Thank you. Mr. Blake, come forward. Restate your name for the record, sir. No, you have 3 minutes.
Yes, thank you. Tim Blake, the Emerald Cup and Healing Harvest Farms Dispensary in Laytonville. To the issue of the state policy, which isn't quite here, but I have a lot of information on that. Sean Parker is with Facebook fame, and he's partnered with Justin Hartfield from Weed Maps. They were going to do an initiative with the DPA. DPA pulled out of that because they felt it was not very conducive to small farmers, and it was really a large-scale model. California Reform is trying to work out a deal with them. They don't have the money right now. California Reform has a lot of influence, but they only have a couple $1 million. Sean Parker and these people have over $20 million. They're going to have quite a bit of influence in the coming election. You'll see over the next 30 days who they partner with and where that money goes. It's going to be a very important, critical issue. I was approached by some farmers down in Monterey County that control over 39,000 acres. And I've never been really worried about the San Joaquin Valley because, as I said earlier to the SFA's people, I think the toxic levels of the air and the water down there are going to keep anything from passing any tests that'll ever come into cannabis cultivation. But I am worried about regions from Santa Cruz down to Santa Barbara. With these large-scale farms down there and the amount of cannabis they're going to grow, they're going to really have a negative influence on us anyway, unless you guys give us a chance to compete with them. And at the Emerald Cup last year, we had almost 900 entries statewide. 25% of those entries came from Mendocino County. This was a blind test with nobody knowing where this came from. Mendocino took 75% of the awards. We absolutely grow the finest cannabis and medicine in this state and in this country and this world. And if you'll just give us an ordinance, it'll give us a chance to compete with these large-scale farms to some reasonable level. We can help this county with a lot of money and a lot of jobs and a lot of support. And that's what we want to do. Thank you.
Thank you, sir. No, like, no interruption. You see, you can do this. Saw lots of those. Can tell some of you have been here before. Ukiah Morrison, please.
Ukiah Morrison, thank you for your presentation today, Mr. Smith, and thank you, board, for having this event here today. I wanted to address my own personal issues, which I know are near and dear to many of the growers in this community and in the area at large. With regard to the environmental degradation that comes from illicit grows, I think every one of us is in support of changing that. No one wants that to happen. But at the same time, I caution you against allowing certain provisions in the law that allow for large grows to continue that will not take quite the same sort of perspective that a small-time grower can afford to do. And I'm really mindful of that we can do better, and I don't see that these regulations are going to make things better. I see them as a step in the right direction. We all want structure. We would love to have licensing, but don't make it so that it's impossible to acquire. I have 12, 17 licenses and permits. That seems like a lot of flaming hoops to jump through. As far as the dispensary ordinance is concerned and what we might be able to do with that, maybe we could reopen the old post office and make that something worth going to again. I love the mural in there, and I love to visit the people, and I really want us to be conscious of what's going to happen. I mean, again, I just want to reiterate, we all want structure, but we don't want to be pushed out of the market. And the other thing I really am concerned about is when we have bigger farms doing this, we're going to end up having a lot of the diseases and infestations that are going to be more problematic with that type of process. So I think, again, it revolves around a small grower like we have in Mendocino County. Thank you.
Thank you. Anyone else, please come forward. Seeing no one, it's back to the board. Board members, I believe we're going to have the legislative platform for the coming year. So be thinking about that and language that we can put in the ledge platform. That committee has not, the ad hoc has not been appointed. But I also heard Mr. Smith say that at an upcoming RCRC meeting on AB 1548, there will be discussion, and I will be voting After that discussion, taking a position on behalf of Mendocino County. So possibly we will need that in an upcoming board discussion. Standing committees, we are thinking about forming them at the first of the year. We do have an ad hoc on marijuana. I don't know if we want to go forward on that, but that should be another discussion on one of our upcoming agendas so we can get started in the right direction to move forward. Supervisor Hamburg.
Yeah, I was wondering if the ad hoc, which is Supervisor Woodhouse and Supervisor McGowan, have a plan to bring anything forward to the board during this calendar year, or I mean, we only have 4 Board of Supervisors meetings left this year, so.
I think someone's getting ready to respond to that. Supervisor
Yeah,
McCallum.
I am curious about that. And also, I do hope we can, either when the ad hoc is ready to report to the board, and I don't want to jump over what the ad hoc is going to present, but I do think this issue of the plant count, it's been coming up for many, many, many months, and now we're obviously moving into a whole new ball game in a matter of months. January is just around the corner. I don't even know what a small. I mean, I really like this idea, and I've said this for many, many years of small farmers and of this being an industry of small farmers, and the idea of industrialized marijuana has always seemed to me to be just a horrible thing. And Ukiah, you pointed out one reason it's a horrible thing, and that indeed will happen. You will have more infestation, you will have more disease, you will end up using more substances to try to meet the the health and safety standards. But I personally don't even know. I mean, if you're talking about raising the plant count in Mendocino County, to what? To 40,000 plants so we can compete with Philip Morris? Or I mean, what are we really talking about? Yeah, okay, 99, and
Okay,
it does.
you're out of order.
Okay,
please.
so that's one thing that I do
Don't
hope
ask questions.
we address. And the other thing is this whole question of whether before the end, whether as soon as possible we should adopt an ordinance that is along the lines of what the state has done, so that our farmers and our dispensary owners and so on are not disadvantaged. Because if AB 266 section whatever says that there shall be priority for those farmers and those businesses that are in good standing in their local jurisdiction prior to January 1. Thank you.
Thank
Madam
you.
Chair.
Supervisor McCallum.
Thank you, Madam Chair. Well, the current ad hoc, really, I believe, if we go back and look, was tasked with monitoring state legislation and assisting in responding to state legislation. And we largely did that through the work we did with the 6-county Regional Policy Committee, and produced a statement strongly in support of local control. And most of those provisions did or were included in the legislation. They largely echoed policy principles that had been adopted by the RCRC and CSAC. So, it does seem that we've come to a point where it's appropriate to either reassign the task of the ad hoc or even reconfigure the ad hoc. And I'm not immediately concerned with plant count, I have to say. I am concerned with the March 1st deadline. And so I do think it's time. I think the phrase was used, dust off our existing ordinance and take a good look at it and see how it meshes with the legislation that's been adopted. And in many respects, and I think it's been brought out here today. What's been adopted is really a series of concepts, although there's a lot of specific language in there about who shall do what. There's language describing 10 different cultivation licenses. So apparently they, at the legislature, they were not really in tune with the principle of keep it simple. So I do think Mendocino County does need to consider updating our local ordinance to make sure that we don't put ourselves in a position where the state is making even more decisions for us. But one of my immediate concerns is changes that may take place in January in the state legislature that will be disadvantageous. And a lot of it centers around this one section that was identified, was at 11360.2.77
G.
See, so, you know, there's a belief on many marijuana activists that everybody should have complete freedom to grow cannabis wherever they would like to grow it. So I've got a backyard, why can't I grow it in my backyard? And everybody can legally go out and buy as much milk as you want, but no one expects you can have a herd of dairy cows in your backyard if you're in a residential zone. So, you know, that'll be a battleground, but I think it's activists putting personal interest ahead of public interest. We'll see how that plays out. And I'm getting the signal from the chair to wrap this up. So I do think that the ad hoc should discuss the issues that are before us and work with the executive office to bring a recommendation back to the board on, I think, possibly repurposing the ad hoc so that we do dust off 931 and decide what changes do need to be made to make sure that we conform to state law and put Mendocino County in the best position we can be going forward.
Supervisor Woodhouse.
Thank you, Madam Chair. With Supervisor McCowan's permission, the ad hoc committee will be having a meeting after this meeting for 2 to 3 minutes and picking out a couple days for us to get together. Thank you.
Supervisor Jurdy.
Well, I'm going to add my voice to supporting acting as quickly as we can so that we have something in place prior to March of next year, and also to state the obvious that I think in addition to looking at the state law, I think it makes a lot of sense for staff and the ad hoc committee to look at the draft that was prepared by Humboldt County staff, because there may be some good ideas in that would work for Mendocino County.
Okay. Going forward, so do we want to make a motion on action, or just what you brought forward is how you want to go forward? It'll be on our next agenda item.
You know, frankly, I don't think we have the information in which to make a motion. You know, I think the appropriate action is to expect there will be a future agenda item, probably sooner rather than later. But yes. I don't think we need a motion for that. Okay, and so we will look forward to having that in the next couple of meetings? At least by the second meeting in November. Okay. All right.
Okay.
Well, that sounds good to me. Okay, I want to thank you, Mr. Smith, and before adjourning today, I want to recognize our acting county counsel. She just got through her first meeting, which is very short compared to Tuesday's meetings. Catherine Elliott, welcome aboard. Okay. So we're going to adjourn, and thank you all for being here. I hope it was worthwhile and informative for you. Thanks.